Right from the start, this hearing is already loaded. Anytime the state moves to terminate community control, basically probation, it means they believe the defendant has violated the rules badly enough to justify prison time. Watch closely, because what begins as a standard violation hearing turns into a full courtroom meltdown.
Ms. Ronick?
Thank you, Your Honor. Present the matter of State of Ohio versus Shaquila Brady, case number 23CR000840. The defendant is present in court with defense counsel Nicole Novotny. We are here for purposes of a final hearing on a probation violation. On June 13, 2025, the state filed a motion to terminate the defendant's community control sanctions based on violations of Rule number 3 and Rule number 8. It's my understanding that at a probable cause hearing, the defendant was apprehended, and based on the drug testing that occurred after her apprehension, state then filed on July 1st, 2025, a supplement to motion to terminate defendant's community control for a further violation of Rule number 8. It is my understanding that the defendant wishes to waive her final hearing and admit to the violations today. Thank you.
Ms. Novotny?
Your Honor, that was my understanding before coming in here today.
Whoa, this is a major turning point. Firing your public defender right before a violation hearing? Judges hate last-minute shakeups because they delay the process. And legally, defendants can't just choose a different free lawyer. They only get to choose a retained one. Expect tension.
However, before you entered into the courtroom, my client is now saying that she would like to fire the public defender's office at this time. I believe she can have more of a say on her thoughts and feelings now. But
I'll hear from her. Ms. Brady, you want to be heard on some issue?
Yes, Your Honor. I just don't feel like I'm being heard correctly. Like when we had the probable cause hearing, I was told to waive it, and it was guaranteed rehab from my public defender. I even told her on that day, and I hope it was recorded on that day with your bailiff in here, that I didn't feel like she was representing me correctly and that I wanted to fire her then, and I would get a paid attorney. And she told me that
You can get a paid attorney anytime you want. You don't have to. You don't have to have a public defender fired to get a paid attorney. You can retain an attorney anytime you want to retain an attorney.
Well, I'm just not comfortable going through with this again sentence here when I feel like everybody is, none of my family is here. Nobody is here on my behalf.
How is that our fault?
No.
Why aren't they here?
Because I wasn't able to tell anybody.
That's because you were being disciplined, probably. Or using the phone for wrong purposes, or flooding your cell. But
I'm sorry, Your Honor. Like I'm just.
the fact that your family is not here has nothing to do with the public defender.
I just don't feel like she's representing me correctly. You know, the information that she has given me is false. I know I did a hair sample. She wants me to plead to something that I did not test positive for. I don't know why they said this. I did a hair sample. I asked her to reach out to my social worker, Grant McKay. I have the paperwork that I brought here when I came for the probable cause hearing on the 27th, saying that I did the hair sample. So none of this. So I don't feel comfortable pleading to something that I didn't do with the possibility of prison, and you told me that you weren't giving me any chances. So I just feel like my back is against the wall. I'm just not comfortable. So I just don't want to. I just right now don't feel comfortable going through with this hearing. Like I don't know.
Well, you're not going to get appointed a new lawyer. You don't have a right to.
No,
Let me talk. You have the right to have a lawyer appointed to represent you. You don't have a right to pick and choose who your appointed lawyer is going to be. Now, if you want to get a retained lawyer, you can do that. You could do that anytime you want. You don't. But you haven't. They're not here. I don't see them here. Why aren't they here?
I mean, I have not been able to make those necessary calls because like I said, I was told that. She's shaking her head. I was told that rehab was definitely it. You get what I'm saying? Like and then now it's like she's saying. She never told me this at the probable cause hearing. Lake Geauga prison, and so I'm asking what probation is recommending, which I kind of understand. I mean, but I don't feel like that's needed for me because I have a problem and I do want to get it treated. It's not like I was just going against what you were telling me to do. I was doing everything. I got the sponsor. I was doing the 3 meetings a week. I just couldn't get out here. I don't drive.
Well, since you...
This section is crucial. The judge is building a record showing the defendant's behavior after the alleged violations. Even though these aren't new criminal charges, they can still influence the judge's final sentence by showing a pattern of noncompliance. This is how courts justify harsher penalties.
Been here, you've been disciplined, let me see, 1, 2, 3, 4, 5 times in the jail since the probable cause hearing. So things could change based on your conduct, you know.
I can't redeem myself here just because what I did my previous time here. So I can't.
I'm not talking about that. I'm talking about since July 4th this year. You were in court for that probable cause hearing on July 1st, and that's when you're saying that these representations were made to you. Since then, you had an incident with the lockdown, with some incident with a day in advance on July 4th. There was an incident on July 6th. On July 10th, there was a physical altercation. Is she being charged separately for that and another criminally for that?
I do not believe so.
Okay. There was a separate incident on July 10th when you got into a fight with someone. On July 14th, you were supposedly using the phone to call your public defender, and you really weren't. You were using it to call somebody else. And then this past Saturday, you flooded your room. So it's 5 things that have happened since you were here. So even if you were made some representation, things can change based on your behavior and conduct. You also refused to even talk with the folks at the NeoCap. So things could change based on your behavior.
I understand that, Your Honor, and I do apologize for that, but I was assaulted.
You were what?
I was assaulted first on the 10th, so I defended myself. I have always, I defended myself. I was assaulted first. She threw something in my face from across the
What about the phone call? What about flooding your cell?
I was using the bathroom and I was flushing the toilet, and it kept overflowing. That's how the whole room flooded like that. It went.
You know, I'm not going to argue with you. If you want to be given a week to retain a lawyer, I'll give you some time to retain a lawyer. If you don't retain a lawyer, public defender's office is going to represent you. You, again, have a right to a lawyer to represent you. They're very good lawyers. They do well what they're doing, what they do. Ms. Navani's a very good lawyer.
I believe so.
And you're going to be represented by them unless you want to retain a lawyer. If you want to retain a lawyer, I'll continue this to give you an opportunity to retain a lawyer. But if you don't, public defender's office, I'm not appointing a different lawyer to represent you.
I'll definitely get a lawyer.
Okay, then I'll continue this for...
But what I'm saying is, too, Your Honor, they have me on discipline, so I need to be able to call and make the necessary arrangements for
You need to not conduct yourself in a manner which gets you on discipline.
Your Honor, all I'm saying to you is, I am not this type of person. I don't go through this on the outside. I don't do fights on the outside. As you can see, I don't do this on the outside. Like,
You're here.
You said I'm here?
You're in court. You've been convicted of felonies on the outside. I mean, something you did that brought you here.
This is the first time I've ever been convicted of a felony, Your Honor. I mean, and not saying that make it any more okay. Because, I mean, how do I get to 33 and then catch felonies like this when I'm supposed to be having my life on track at that point? So that is fault of mine. But I'm really not this person. But in this situation, it's like fight or flight. And I can't redeem myself just because how angry I was or how messed up I was when I came in back in November. So now it's like everybody in here hates me. You see how you talk, everybody's short-tempered with me. And I get it, but so they pressed my buttons. I mean, the staff just had to kind of like save me the other day because she said like 9 officers wanted to come jump on me because they felt like I could fight. It's not right. It's really not right. And I did call my attorney on that phone call, but he wasn't going to press 0 to accept my call. So I had to call my cousin who was at court for my kids, and she clicked over and called Grant McKay, my attorney. So I did speak with my attorney.
If you want a couple weeks to try to obtain a lawyer, I will do it. We're going to reschedule it. We're going to go forward on that day with that lawyer, so make sure whoever you retain knows they're going forward on this day when we schedule it. We're not going to continue it again.
I'm going to just go for it now. I can't do this.
I'm sorry?
They're not about to let me just be getting on the phone. I'm on discipline. So it's just prolonging it. Let's just go forward today.
You want to go forward today?
Yes.
Well, what do you want to do? Do you want to have a hearing? Let me explain to you what you're charged with.
Quick legal breakdown. A probation violation hearing doesn't work like a normal criminal trial. There's no jury, and the standard of proof is lower. But the stakes can be huge. Violating probation often sends people straight to prison. Would you plead guilty here, or fight the charges? Let me know what you think.
Here.
Are we on
You had,
record?
sorry?
I'm sorry, are we on record?
Yeah, everything we said is on record from the moment I walked out here. You have been charged with violating the conditions of your community control sanction. Specifically, it's alleged you violated Rule 3, which requires you to report at such times and places as directed by your probation officer. And it's alleged that you failed to report to your probation officer on May 15th and June 5th. It's also alleged that you violated Rule 8, which prohibits you from using, possessing, or having under your control any controlled substance not prescribed to you by a licensed physician. And it's alleged that you submitted a urine sample to the Cuyahoga County Children's Services on April 18th that tested positive for phencylamine. It's also alleged that when you were arrested on the warrant in this case, you submitted a urine sample that tested positive for opiates and cocaine. That was on June 27th, so there's another Rule 8 violation. So you have a right to have a final hearing regarding these allegations, which is a hearing where the state would be required to prove the merits of what they're alleging. You could have this hearing, but you can also waive the hearing and admit to the violations. What would you like to do at this time? Do you want to have the final hearing, or do you want to waive the hearing and plead guilty to the violations?
I'm gonna plead guilty, Your Honor.
Very well. As to the first allegation that you failed to report to your probation officer as you were required to do so on May 15th and June 5th, what is your plea to that?
Guilty.
As to the allegation that you tested positive with Cuyahoga County Children's Services on April 18th, what is your plea to that?
Not guilty.
Well, you just said you plead not guilty?
So that one, yes.
All right, well, you can't. Then we're going to have a hearing. I had said before, you either want to have a hearing or plead guilty to the violations.
Okay, guilty.
We can have a hearing. I'm all right with that. I don't want to force you to do anything. You had said that you wanted to waive.
I thought I didn't know each one. I don't catch court charges, so I don't really know about this process.
You're charged with 3 violations, as I explained. So you'd have to plead guilty to 3 of them, or we'd have a hearing.
Guilty.
As to the allegation that you tested positive for cocaine and opiates when you were arrested on June 27th, what is your plea to that?
Guilty.
The court will accept your pleas of guilty, find that you did violate your community control sanctions. Ms. Novotny, any reason not to go forward with sentencing?
Your Honor, we may.
Anything you want to say on behalf of your client?
Yes, Your Honor, we would like the court to consider her for community control and extend that. Ultimately, our office submitted and worked with Erin Mayer, our social worker, worked with Nora. They have a bed available for her to go to upon release if the court is inclined to do that. So I did submit a bed letter for Nora for Ms. Brady.
This is the defense's strongest moment. Notice how the attorney highlights treatment, progress, support programs, and childcare responsibilities. This is classic mitigation strategy. Show the judge that rehabilitation, not incarceration, is the better option. Whether the judge buys it is another story.
To go to with that respect. She's been seeing Signature Health for over a year, Your Honor. I know last time you've seen her, she has a sponsor now. She has a referral for peer support, which is 1 time a week. I know she wants to start anger management. She was supposed to start that on July 9th, but due to her incarceration, she couldn't start that. Additionally, she was doing aftercare, which did conflict with the anger management times, Your Honor, so she wasn't able to start anger management. Ultimately, she was set to complete aftercare. She was completing that and doing everything she needed to do with that respect. For Signature Health, she was going there for case management services. She was going there for counseling, Your Honor. She was going there for aftercare, and she was going for mental health and drug help with regard to medication compliance. Thereafter, Your Honor, she is working with Job and Family Services with Cuyahoga County too for a case plan for her children. She's diligently working with that. I did talk to a representative from there as well as her Robin from Signature Health to confirm all of this. We're just asking for you to consider her to continue on community control at this time and send her to Nora.
Thank you.
Thank you.
Ms. Brad, you have the right to address the court before you're sentenced. You can say anything you want. Is there anything you want to say at this time?
Yes, Your Honor.
I'm sorry?
Yes, Your Honor. I want to say that I know I messed up. I failed, but I didn't just lay there like I would usually have done. I still continue my services because I do want the help. It's just hard for it was hard for me to do something that I never done before. I was not trying to rebel against what you told me to do. It was just hard for me to get out here because I don't drive, and I had got my foot ran over by my kid's father. He was in jail. The boys were placed with me. And it was just hard for me to get out here the 2 times that I couldn't make it. But I would never, if you trust me this one more time, I would never not come and see her. I don't care what I gotta do, learn the bus route. I would never not come. I would do everything I gotta do at Norris, but I do got a lot on the line. Like, this is my livelihood. I got a whole house. My lease is about to be up. I was doing programming for that. And I had to do other programming to extend the lease. And that my lease is up is August 31st. And it's a year lease. And, you know, the judge, he rescheduled my court date from July 14th for my kids to August 18th to see because he wanted to see me. And I really want my kids, and I asked for peer support through Signature Health because I do want to know better people. Like, I went home to the same situation, like just the same people, didn't want to be alone, and I fell victim. And I mean, I'm grown, so I should know better. And I'm sorry, I'm so sorry, but I'm just begging you for another chance. I'm begging Jamie to give me another chance. I know better now. Like, I know this is not a game. This is my life. I want better, and I'm going to do better. Just please give me another chance. I know here I've been messing up, but my whole life has been fight or flight, and I just got to get out of that. If I could have done the anger management, even after all the stuff that Children and Family Services being involved, my kids being taken, and they have never been took for abuse or drugs. They were taken because of my attitude, but they have never, ever they never care about the betterment of me or my children. They never recommended anger management, so I never even had that to even go off of in the real world. But I love my team at Signature Health. They really helped me. Like, I don't hide nothing from them. That's why I was doing the urines. That's why I wasn't trying to pull the wool over their eyes or take fake urines. Like, I want the help. So please take that into consideration, Your Honor. Thank you.
Ms. Schrock, the State of Ohio.
Thank you, Your Honor. The state's going to ask the court to adopt the probation department's recommendation for to terminate community control sanctions and impose a prison sentence. Thank you.
This court reviewed the original pre-sentence report investigation and considered the facts and circumstances of the underlying offense, the nature of that offense, considered the defendant's history and probation, the nature of the violations, and everything that's been said here today by Ms. Novotny, the defendant herself, and the recommendations. All this is considered in light of the purposes and principles of felony sentencing set forth in 2911. As for the factors in 2912, I'll incorporate all the findings I made at the time of the original sentencing regarding the seriousness factors and the recidivism factors, with the additional finding today that the defendant has failed to comply with previously imposed sanctions ordered by this court, which is a factor indicating recidivism is more likely. In this particular case, since the very, very beginning, at the defendant's arraignment, which I presided over, she's had a horrible attitude. She's been very defiant, and that's just continued.
I need the anger
That's just continued. I ordered anger management and you didn't get it.
Your Honor, I had to do the aftercare first. It would have conflicted. I couldn't start regardless until July 9th. That's when the next cycle started. I had got out of jail on March 3rd, Your Honor. I instantly got into aftercare.
Okay, it's my turn to talk now.
Yes, I'm sorry, Your Honor.
From the very beginning, as I said, she has been defiant, and had a terrible, terrible attitude, and that's continued here today. As I indicated earlier, just in the...
Here comes the final blow. Listen closely. Once a judge says a defendant is not amenable to community control, that's basically the legal green light for a prison sentence. Everything said earlier, attitude, jail behavior, missed appointments, was building to this moment.
Last 2 weeks, She's been disciplined 1, 2, 3, 4, 5 times in 2 weeks for not following rules in the jail. She was asked to be just simply interviewed by NeoCap because they were trying to provide additional help and get her what she needs and provide her resources. She absolutely refused to even talk with them. It's clear at this point that Ms. Brady is not amenable to available community control sanctions. I'm not quite sure she ever was. Prison is consistent with the purposes and principles of sentencing. Therefore, it will be the sentence of this court that on count 1, defendant served a term in prison of 12 months. On counts 2 and 3, she served a term in prison of 10 months. I'll run all 3 concurrent for a 12-month prison sentence. She has credit for 155 days. Need to advise you upon your release, you may be placed on post-release control for up to 2 years. If you are and you violate any of those conditions, the parole authority can return you to prison as punishment for violating the rules for another 6 months, the maximum being 50% of what I just imposed. Any additional prison term imposed for violating post-release control is being imposed as part of the sentence at this time. Court disapproves the defendant's placement in any program of shock incarceration, intensive prison program, or transfer to transitional control. The defendant's ordered to pay all costs. Is there anything else for the record, Ms. Hronik?
No, Your Honor, thank you.
Ms. Novotny?
No, Your Honor.
You'll prepare the entry, Ms. Hronik?
I'm sorry?
You'll prepare the entry?
Yes, Your Honor.
Thank you.